forgot to hand up those two judgments. I beg leave to hand them up. It's the Tubular Holdings and the Freeman judgment. Thank you. And then just one other issue. I also forgot to give the court the citation of that Concord public protector case. It's Speaker of the National Assembly versus Public Protector and others, Democratic Alliance versus Public Protector, and the citation is 2022, volume 3, SA, page 1, CC, Constitutional Court. And about that, both Justice Lefranc and I misled the court.
I misled the court.
So, on a more serious note, I agreed with Justice Lefranc, or he agreed with me that was an appeal of the Saldanha jail judgment.
I thought it was that.
Yes, it's not.
Oh.
Just for clarity, not that anything turns into it, but that appeal, very briefly, was, remember, Saldanha J was Part A.
Yes.
Then we came here for Part B.
Was that Part
in front of Batman J, another full court. Then we were successful on those two grounds. One of the grounds was legal representation. The other one was whether a judge can be part of the panel. And then the Speaker appealed and the DA to the Concord. So that's what that case was. The Speaker then appealed, and then in the appeal, they were successful on the judge point, which is why Judge Nobo wasn't there. But they were unsuccessful on the legal representation point. Just wanted to clarify that. Just
Thank you,
in case
Mr.
Judge Saldanha thinks that I'm misrepresenting you. Thank you. Thank you. I'm delighted to say it.
May it please the court. I submit with respect that to understand paragraph 7 of the Constitutional Court order, one has to read it in the context of the order itself. And the important context is paragraph 3 of the order, which introduced the new rule 129I, and that rule, if I may just pick it up now in the amended form, says once the panel has reported, the Speaker must inform the Assembly of the report. 2, the President must be provided with a copy of the report forthwith. And then 3, and this is the key to the understanding of paragraph 7. 3 says, in the event the panel concludes that sufficient evidence exists as contemplated in Rule 129G, the matter must be referred to the impeachment committee established by this rule or by National Assembly rules for that purpose. So that the rule says if there is an incriminating finding, then the report must go to the impeachment committee. And we submit with respect that that explains paragraph 7, because the court then found that the original rule was invalid, set it aside, and then the court gave effect to the new sub-rule 3 by saying the report of the independent panel is referred to the impeachment committee established in terms of the NA rules. It does no more than to give effect to the rule. And what is important is that the order merely gives effect to the new rule by saying if it's an incriminating report, it must be referred to the impeachment committee. And it stops there. It doesn't go on to express any view or make any order as to what should then happen to it. In fact, the court is silent about it because the rules then take over. The rules 129 M and N then take over, and the matter is regulated by the further rules of the committee as to how the impeachment committee must then do its job. But there is nothing in the Concord order to suggest anything about what should happen after referral to the committee. So, and also just to clarify, to go back to that rule, because my learned friend Mr. Ramaphosa interpreted the new rule in a way which we submit is not justified on a small aspect. That's the new rule 129.3, the one to which I've referred. Just to read it again, in the event the panel concludes that a sufficient evidence exists as contemplated in Rule 129G, the matter must be referred to the impeachment committee established by this rule or by the National Assembly rules for that purpose. My learned friend suggested for that purpose means
Ding, ding, ding! It's a knockout! We'll beat your premium or pay you the difference of up to 2,000 Rand. For a limited time only. Get a quote now.
by this rule for that purpose. So it doesn't say anything about what should happen to the order. It merely describes the committee to which it must be referred as the committee as the impeachment committee effectively. So the rule says nothing, the Concord order says nothing about what should happen after the referral. It leaves that to the rules which prescribe what should happen. So it is not correct to submit, as a number of my learned friends did, it's not correct to submit that the Concord order said anything about the way in which the impeachment committee should deal with the report. Those are matters regulated by the rules and not by the Concord order. Can I turn to a different topic, and that is the requirement that the President shows a prima facie cause of action. Now, the President identifies the causes of action or the grounds of review upon which he relies in his founding affidavit from page 11 in paragraphs 45 to 78. And I just wish to emphasize that the President persists in relying on all of those grounds of review. I highlighted two of them merely because they seem to us to be unequivocal and therefore beyond debate. But you mustn't understand that the President has abandoned the others. He still relies on them. And but as I've said, I have focused on two of those requirements, and I just wish to add a few words about them. The question, the first is the satisfaction of the requirement of sufficient evidence. It's a matter much debated yesterday, but if I may come back to it, to emphasize that what the panel is required to do is to assess whether there is sufficient evidence to refer the matter to an impeachment committee. The panel interpreted that to mean whether there is prima facie evidence of a transgression. We submit that more is required than that. We submit with respect that the suggestion yesterday or the characterization of our submission by saying that what is required of a committee is a qualitative assessment, not a mechanical assessment, but a qualitative assessment, is an appropriate way of describing our submission on the function on the committee. And we just wish to make the following submissions in support of that understanding. One needs to understand, as the bench mentioned yesterday, that the independent panel sits with a large volume of information before it, and it can be a mix of even newspaper reports, hearsay evidence, and any number of sources of evidence, not of the kind distilled and subject to rules of admissibility of a court of law, but a mishmash. And that mixed bag may include mere newspaper articles, hearsay statements, rumors, and the like. Now, if the test is merely whether there is a prima facie case against the president, then it would be a very artificial exercise to take these newspaper articles, hearsay statements, and the like, and simply ask oneself, as one does for prima facie purposes, is there evidence here which, if true, would render the president guilty of serious misconduct? That would be an entirely inappropriate exercise, because that would not weigh the significance of the evidence in any way. We submit what is important is to make a qualitative assessment that says, I take into account everything, the first-hand evidence, the newspaper articles, the hearsay statements, and the president's explanation, the president's statement. Take all of that into account. I don't ask whether the president is guilty, but what I do ask is, taking into account all of the evidence and the various mix and matches of evidence, taking all of that into account, is there sufficient evidence to put the president on trial? In other words, to refer the complaint to an impeachment committee. So it's a qualitative assessment of the information. I don't even call it evidence, because I accept that it may include lots of information. A qualitative assessment.
But Mr. Trencliffe, if one have regard to the report, and as you correctly pointed out, and the Respondents' Council as well, we should just have a peek into that report. If one have a peek at that report, isn't that exactly what the panel did before it started to go through and shift through all of those materials?
No, but with greatest of respect, what it itself tells us is that what it ultimately asked itself is there a prima facie case? That's what it asked itself. And that doesn't suggest any weighing up, any qualitative assessment. It simply says, is there a prima facie case? And we submit with respect. I'm not seeking to persuade you that if they had applied the proper test, they would have come to a different conclusion. That's not the debate before you. The question merely is, did they apply the right test? And we submit with respect that they tell us that what they did was to ask themselves whether there's a prima facie case, when what the rule requires is sufficient evidence, which is a bit more than that, requires a qualitative assessment. Can I give you, by analogy, another example that I came across last night? And that's this. It is the NPA's prosecution policy. It's an official document prepared by the NDPP under the Constitution. I beg your pardon. Prepared by the NDPP under the Constitution, which sets out the policy of the NPA. One of the issues they address is the manner in which prosecutors must exercise their discretion when they decide whether to prosecute or not. Now, that NPA policy was described in a judgment which has been uploaded, but let me just give you the reference. It is DITUKU, that's D-I-T-U-K-U.
Just D-I?
D-I-T-U-K-U, DITUKU, V-NDPP, 2024, ZA-NC, it's a Northern Cape decision, High Court 115, a judgment delivered on the 5th of September 2024. And it has been uploaded onto case lines. The case starts at 013-370, but the paragraphs to which I wish to refer are paragraphs 30 and 31, and they are at 013-379. 379. But their virtue, for our purposes, is merely that they recite the prosecution policy. I have also uploaded a copy of the prosecution policy itself. And let me just give you the reference, but then also give you just the page number to which I wish to refer. The prosecution policy is at 013-356. The page to which I wish to refer is at 013-361. And if I may just hand up to the bench that page.
Yes.
This is just an extract from the prosecution policy under the heading General, and it describes, amongst other things, the manner in which prosecutors must decide whether to prosecute or not. And if I may firstly refer to the 5th paragraph, that's just below the middle, where the policy says the following: in deciding whether or not to institute criminal proceedings against an accused person, prosecutors must assess whether there is sufficient and admissible evidence to provide a reasonable prospect of a successful prosecution. There must indeed be a reasonable prospect of conviction, otherwise the prosecution should not be commenced or continued. And if I then skip 2 paragraphs, and I go to the 7th paragraph, the 8th paragraph, this test of reasonable prospect must be applied objectively after careful deliberation to avoid an unjustified prosecution. Now let me immediately say, I'm not suggesting that the standard for the decision of a prosecutor, whether to prosecute or not, and the independent panel's decision whether to recommend or whether to refer to an impeachment committee is in any way comparable. So I'm not holding out the prosecution policy as a guide in the interpretation of the rules. But what I do emphasize is that even in the case of an ordinary prosecution, the question is not whether there is a prima facie case. The question is whether there is sufficient evidence, sufficient evidence for a reasonable prospect of conviction. And the test is set at that standard, they say, to avoid unjustified prosecution. So the only value that the analogy can bring is to say there is a point in requiring sufficient evidence as opposed to just prima facie evidence. A prosecution, impeachment inquiry and a prosecution are not the same thing. But what they have in common is that one must ask yourself, is there sufficient evidence for purposes of this process? Because the purpose of the requirement, the point of the requirement, is to protect the president against impeachment inquiries for which there isn't sufficient evidence. And the president would be deprived of that protection, that qualitative assessment, if the decision by the independent panel is taken on a prima facie basis, because a prima facie assessment looks at the incriminating evidence and simply asks itself whether there is enough, whether the president would be guilty of all of this evidence was true. It doesn't weigh it up, and it doesn't consider the countervailing evidence, or it doesn't attach any weight to the countervailing evidence when it makes that decision.
I hear the point you want to press, Mr. Trenkerhoff, but in this instance here, it is quite evident that the panel was aware that they had to take into account the president's answer, an affidavit which he filed.
Well,
They've considered that.
No, they didn't.
If one have regard to paragraph 73 and 70, well, let me say from paragraph 74, 75 and 76 of the panel's report, they set out as to what they need to do, and it appears from looking at this panel report that they indeed consider the evidence of the president. They might have used the word prima facie, and you might suggest that prima facie is just taking into account the incriminating evidence. That might be so, but on this fact we've got before us, they did indeed take into account the affidavit of the president.
with respect, my lord, I accept that they read the evidence. They recited some of it, but there is nowhere in their report a weighing up of what we have on the one hand and what we have on the other, and why it is sufficient in what we have. There's simply a recital, and then after the recital they said, the question before us is whether there is a prima facie case. Well, then there is. It is not a conclusion founded on a weighing up. It is a recital of for and against, and then said, but our question is whether there's a prima facie case.
So what do you say about the argument made by Mr. Katz with regard to, if you look at the affidavit filed on behalf of ATM, it in fact, there the panel's weighing up and suggesting where there's a deliberate part on the president not to engage with some of the evidence. So the panel indeed said why they came to the conclusion that there was some intention.
With respect, my Lord, we read the report differently.
Oh, you read
There
the
is
report
a-
differently.
No, I accept that there is a recital of much of the evidence. I'm not suggesting that they were unaware of the evidence. But there is nowhere in the report is there a weighing up. This is what the accuser says, and this is what the president says. I find that there is a prima facie case for whatever reasons. There is never any weighing up. And that is because, and with respect, we must take them at their word. They are very accomplished lawyers. When they say we apply a prima facie test, then they know what it means, and that is what they do. There is no justification for not taking them at their word to have done what they said they're doing. So for that reason, we submit with respect that we should take them at their word.
But has the panel, or did the panel define what they meant by prima facie? Is there any indication in the reports when they use the word prima facie what they actually meant?
I don't recall that they defined it.
Surely
But-
then one must look at the context within which that word was used.
Well,
And as my brother has indicated, they seem to have gone through the evidence. They may have used the word prima facie in a different context that you suggest.
well, I don't know how accomplished lawyers could attach any different meaning when they speak of prima facie. They mean on the face of it.
A case to answer.
I beg your pardon?
A case to answer. That's what I would imagine. it
Well,
is.
what is
And
a
that's
ca-
what they say.
But they understood that to mean they use those two phrases interchangeably. Case to answer means a prima facie case. Means there is evidence which, if true, would mean that the president is guilty. But that's a one-sided assessment without balancing the for
How
and
do you
against.
know that they didn't balance? They've had all the information before them. They use a limited techniques and tools at their disposal to come to a conclusion. And says, yes, as imperfect as our particular process might be, but we think that there is sufficient evidence before us to indicate that the president needs to go forward.
And what they
to an
didn't
inquiry.
say, there is sufficient evidence. They said, our understanding of the test is that we must ask ourselves whether there's prima facie evidence, not sufficient evidence. And that is the complaint. If I had said, yes, we have weighed it all up, and in our view, there is sufficient evidence, there is enough to warrant an impeachment inquiry, that might have been a different matter. The other ground of review that we emphasize is that the panel failed to assess whether the president deliberately, in bad faith, broke the rules he is alleged to have broken. Now, our learned friends have pointed out that the panel was aware of the requirement of bad faith. But when it came to assess some of the specific charges, and we singled out two of them. The one is the other paid work charge, and another one. You would have to find that the president knew that he was not allowed to have this business interest. Now, not only was there no evidence on record that the president actually knew that, but all the evidence was to the contrary. And the committee never asked itself that question. It never asked itself whether we can say that the president deliberately failed to comply with this rule. The same is with the Section 34 charge. The high water mark of the committee's assessment is that the president should have reported the matter under Section 34 and not only reported it to General Rueda. But bad faith requires evidence that the president knew that he ought to report it differently and failed to do so. And there's never any assessment or investigation whether that is so. So we submit with respect that in those two flaws render the report subject to review.
Just on those last two issues,
I beg your-
just on the last two issues you've raised,
Yeah.
on the PRECA and private work, what ought the panel to have done that it did not do with the information before it?
Well, it ought to have asked itself whether there is evidence on its version, prima facie evidence, that the president knew that he was not allowed to keep the farm and that he had to make a report to the Hawks and not to General Rueda. You can't ignore that requirement of bad faith simply because you don't have evidence on the issue. The panel must ask itself whether there is sufficient evidence that the president willfully failed in those two respects. And there was no evidence that he willfully did.
Didn't it draw inferences? And it was quite entitled to draw inferences.
As a matter of theory, yes, but they didn't, and there was nothing upon which that inference could be based. If they had said, we draw an inference of bad faith from factors X, Y, Z, then I wouldn't have made this argument today, because I accept that the question today is not whether they were right or wrong. The question is whether they applied the right test. But nowhere did they ask the question whether there is evidence that the president acted in bad faith, whether of the circumstantial or direct kind. It was simply not addressed. My learned friend, Mr. Katz, submitted that the president did not have any legitimate right worthy of protection in this case. But with respect, the president, and I think he made it in the context of you can't come here merely to protect a right to review. But the president is here in defense of his right to the protection of the buffer built into the rules, into Rule 129. The buffer specifically built in to protect the president. And if he is deprived of that buffer, if it is not properly recognized and applied, then the president is entitled to review because the buffer meant and designed and emplaced for his protection was denied. So that that buffer is the one under Rule 129C to I. And so he has a substantial statutory right which he seeks to protect in this case. My learned friend, Mr. Katz, also made the point that a mere error of law does not render the independent panel's decision void. Now, of course, it is true that an error of law is a ground of review, but doesn't automatically render the decision void. But if the error is one that causes the panel to apply a different test, then the error is not an error in the air. It is an error which impacted on the outcome of its assessment, so that it would certainly be a fatal error if it was made in this case. The EFF argued that the president should have taken the independent panel's report on review in November 2022 when it was first published. And we submit with respect that that is not correct. The president initially made an application for review directly to the Constitutional Court. But shortly after that, the National Assembly voted not to refer the matter to an impeachment committee. In other words, the report was rendered moot. There was no further consequence could flow from it because the National Assembly had already voted it down. The report only came back to life again in May this year when the Constitutional Court gave judgment. So it is not fair to suggest that the president should have pursued a further review 3.5 years ago after the National Assembly had voted down the report. The EFF also argued that the president is merely a witness before an impeachment committee, and therefore there's no harm in proceeding with such an inquiry. But with respect, he's not merely a witness, he's accused number one, or he's the only accused before an impeachment committee. So the two are simply not analogous. And it is because he's the accused, and it is because the accusations against the president of serious misconduct are very serious allegations that the buffer is built into the rule. So it's not correct to say that he's merely a witness. But my lords, on this occasion, where the only relief sought by the president is an interim relief, this is not the occasion on which to make the fundamental, or to determine the fundamental disputes about the legalities of this case. As your Lordship had mentioned, my learned friend had submitted, the court is required to take a peek into the causes of action advanced, merely to satisfy itself that there is a prima facie case, without determining their validity. And what the Constitutional Court said in Eskom Holdings, that's the case we've already referred to, Eskom Holdings v. Vaal River Development, 2023 4SA 325, in paragraph 303, the court said, referring to the outer separation of powers, prejudice, and so on, the court said the following: but courts must never lose sight of the fact that this remains a balancing exercise. Affected fundamental rights must always play a critical role in the balance. And I skip a sentence. The ultimate question is, what is the outcome dictated by the balancing exercise? So what you are required ultimately is not to determine all of these disputes, but to look and take a peek into the box of grounds of review, satisfy yourself that there is a prima facie case, and then do the balancing exercise. And we submit, in this case, the balance is easy to strike. Because on the one hand, there is a risk of unlawfully depriving the president of the buffer designed for his protection. And that would be an irreversible prejudice suffered by the president once he's had to suffer the humiliation of an inquiry. As against that, he asks for a 2 to 3 month delay of that inquiry. And we submit with respect that there is obviously nothing to be said in striking that balance for proceeding at the risk of doing irreversible injustice on the one hand against a 2 or 3 month delay on the other. My learned friend Mr. Katz has said, well, 2 or 3 month delay will trigger a delay which can run deep into next year because Parliament has all sorts of other activities that they have to attend to. But with the greatest of respect, it's firstly significant that it's the ATM who says so and not the committee. The committee has not said that we won't be sitting until deep into next year if we can't do it now. And in any event, it wouldn't be appropriate for the committee to say that if we can't do a hearing now, we'll have to delay until next year because we have other things to do. This is a high priority task of the committee, and the committee should, instead of taking its annual break, do whatever is necessary to hear and determine this complaint as and when the time comes. But the burden of that delay for their own purposes should not be borne by the President. May I lastly say something about costs? My learned friend assumed yesterday that the President pays all his own costs. I understand that that's not so. The bulk of his costs are apparently paid by the state, and the President pays some of it. I have no greater detail than that. I've just put on record that the President does not want to stand by when that misunderstanding is publicly made. But as far as the orders for costs are concerned, we submit the following. The first is that the President is a BioWatch litigant. As between the President, the Speaker, and the committee, the BioWatch principle governs costs, which means the President is entitled to his costs if he wins, but each party pay their own costs if he doesn't. As for the other respondents, the president didn't bring them to court. They have joined in pursuit of their own interests. And I'm not suggesting that they joined in improperly, but they are here in pursuit of their own interests. And for that reason, the president should not be exposed to an order for costs either for or against them. Each party should pay their own costs. Thank you, my lord, my lady.
Anything further to ask? Just one question. Yeah. Just to go back on your penultimate point about the humiliation that the president would suffer if this matter were to go ahead and the review was successful. Now, it's going to take a long time. There's a review which is set down in September. There might be further legal processes that continue. Parliament has its own agenda and so on and so forth. Now, Section 89, to hold the president accountable, that's really for the people of South Africa, okay, the general populace. So they must also be factored in to the issue of harm. Can something which happened how many years ago, how long is that going to continue for? And waiting for a time when there could be a definitive statement as to whether the president has done something or has not done something. It's keeping the populace, the electorate, in abeyance. So if I understood Mr. Mpofu yesterday, he says it's actually a parallel process. Continue your review, but also let the accountability mechanism continue on its part as well. If there is going to be humiliation and so on, that is just the part of the job, so to speak. When the president took on the position of president, he knew Section 89 was in place. Yeah, simple as that.
My lord, let me just say that the president asks for an indulgence of 2 to 3 months. He doesn't ask for anything more. The fact that there's already been a delay of almost 4 years is not the doing of the president. It shouldn't be laid at his door, and he should not be made to pay the price for that delay. That delay has been unfortunate. A number of parties were to blame for it, but the president was not one of them. So it is unfair to burden the president because there has already been undue delay in this case. Going forward, your lordship has expressed skepticism before about the finality that will be achieved on the judgment in September. Our point is that we can't predict what the future might bring, but what we can assure you is that this court will be in charge of whatever happens then. It will deny leave to appeal. It will deny a further suspension. So it will be in absolute control. And there is no fear that injustice might then be done when this court will be in full control of what happens. So given that the president can't be to blame for the delay until now, given that this court will control whatever happens from September, it is unfair with respect, effectively to deprive the president of his statutory protection only because one is understandably impatient that the process must make progress.
A skepticism on whether September would in fact resolve this matter is perhaps justified by how matters of this sort tend to snowball and continue forever. Even with the best intentions of the parties, we know the stakes are so high, and that is why litigation takes the intensity that it does. So to say that there'll just be a short adjournment or for a couple of months, past experience doesn't bear that out.
With respect, my lord, we're not saying trust the president, he won't take more time. we're saying this court will be in charge of whether there's a further delay. The Superior Courts Act provides for the outcome of a case. If the president is successful, the counterparties may appeal. If the president is unsuccessful, he may appeal. But whether there is then a delay as a result of those attempts, it's entirely in the court's hands.
Mr. Drago, let me just clarify something. On that score, if the review is unsuccessful, then any interdict this court may grant would fall away, because you've asked for a very short interdict. It's until the court makes its decision in the review. If the review fails, that order is gone. If the president wanted any more, he'd have to come and ask for it again.
Yeah,
Just wanted to clear that point up.
absolutely. And let me say, the terms of the order we seek would mean that it expires when this court gives judgment in September, regardless of the outcome.
Correct.
So, and who would be successful then, or who would be the winner, who would be the loser? Would the loser want to appeal? Would the process be delayed if the loser appeals? All of that's in the hands of the court. And there is no reason to fear that injustice would be done, because the courts, if injustice is done, it would only be because the court directed that to be so. But it's not for the president or anybody else to decide.
May I ask another question? We were referred by, I think, both Mr. Katz and Mr. Mpofu yesterday to the two full bench decisions of this court with regard to the public protector, where the argument was made that the court has already said, and as I understand the argument, it's being put to us that the court has already said as a matter of principle, you can't suffer reputational harm if you're a person like the president or the public protector, because you signed up for the office, and accountability is your duty. So that's the argument, and we're being told that that's binding on us, and I'd like to hear your response.
No, with respect, the president signed up to the office, which is protected under Rule 129. It's part of the protection to which the president is entitled. And you don't sign away that right. You subscribe to that right when you become a president. And you don't forfeit it because you're a president. That right is created specifically to protect the president against unwarranted impeachment proceedings. You must understand the milieu in which it operates, where the president has aggressive adversaries forever bent on scoring political points.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks. I start by brain dumping everything I need to get done in a list view. Next, I set a priority and a due date to keep things on track. I create custom statuses to organize my progress exactly how I want. I like to add the action items field so AI can show me the next steps. I add my teammates as watchers so they're in the loop. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
Founded allegations. And there is no, as a matter of public policy, the courts are bound to respect that protection and not to allow it to be taken away.
Anything else?
Thank you, my lord.
Thank you. I see Mr. Mr. Mpofu, Mr. Katz is rising.
My Lord Swanedi, there's something that has been bothering me, and it's twofold. The one is I half forgot to make an address. I'll tell you why it's a half forget.
I can't hear you.
There's something that's been bothering me,
Oh, something wrong.
and there are two legs to what's been bothering me. One is that I half, and I emphasize half, forgot to make the point in my address yesterday. And the reason I say half was because Mr. Trengrove said yesterday something which...
Are you seeking permission to address us?
Yes,
You're
yes,
just starting
I'm explaining
off.
why. Because it really to help the court rather than anything else.
Oh.
My Lord, I object to it. My learned friend has had ample opportunity. I was afforded the privilege of preparing my reply today. You can't just come with further points or new points. The debate is over.
But the reason I asked is because I was expecting Mr. Trengrove to deal with it today, and he didn't. And then it bothers me that the court is going to be confronted with something, and I'm going to suggest that anything that Mr. Trengrove wants to say, pursuant to what I say he can say today, he can say it in writing, but it's really to assist the court in what it's got to consider. That's why it's one narrow point.
I think we should do that. Okay, we will allow him to make a point.
It's a very simple point. Yesterday, Mr. Trengrove said, before I argued about how our complaint on the papers that what's in the notice of motion isn't what he really wants. And I emphasized that in paragraph 1.2 of his notice of motion in this case, the President asks for an order which is not competent. So if the court is inclined to even consider, which we suggest it shouldn't, grant the interdict, it cannot do so on the pleadings papers as filed in the terms that are sought. And I was expecting Mr. Trengrove to come and ask for an amendment today. He hasn't. And that's why I'm here. And what he asks for in the notice of motion, in paragraph, this is the key, pending the review, and the important words are interdicted from what? From commencing the impeachment inquiry. And on the pleadings papers, from the Speaker's affidavit, it is clear that the impeachment inquiry has commenced. So he cannot get the relief to stop something that has already happened. So even with this court to consider granting an interdict, it can't be in the terms that the President has asked. And just to tie up the point, because Mr. Trengrove said something yesterday about, well, if you look at the papers, you can see he's not actually asking for the commencement to be stopped, it's actually the witnesses. But if you go to paragraphs, and I'll just give them to you because I don't ask for any more time than necessary. If you turn to the founding papers, they are geared specifically to commencement. And the court can have regard to paragraphs 92, 101, 112, and 120. May I just read 120 of the founding papers? If the impeachment inquiry commences.
Just hold on, let me get there.
Sorry.
We also want to get there.
Sorry.
Yes?
Paragraph 120. Well, I've given you the paragraphs.
Yes, yes.
If the impeachment inquiry, importantly, commences while the review application is pending, substantial portions of the inquiry will be completed before the review. Then, I just want to make the last point, just to tie up the pleadings point with what the facts are. The facts are, if one looks at the Speaker's affidavit, the Speaker's affidavit makes it clear the timeline as to what happened post 8 May 2026. And she makes it clear from her timeline that the commencement was sometime in May, either the 15th of May or 20th, sometime in May. And this application was launched on the 12th of June. So when this application was launched, the President must have known that he could not get the relief of no commencement. So the court cannot grant an order in respect of something that has already happened and to try to stop that. You cannot do that. At the court, no. I had given in my bundle of authority 2 cases to that effect, but it's a trite principle. You can't, once the horse has left the stable, you can't stop the horse from leaving the stable. As it is.
Thank you, my lord. My lady and my lord, 2 things I want to do. One is, I didn't want to interrupt my learned friend, but when he raised his points about the D2 coup and all that, that entitles us to respond to that, because that's just new. It doesn't come from his earlier. He should have raised that case. I'm not blaming him. I say he should have raised it in chief. He didn't. If he found it yesterday, he found it yesterday. But that can't deprive us of a response. The second point is that in any event, strictly on the points in limine, we have a right of reply. And obviously, we mustn't stray into the merits. And my learned friend, Mr. Kari and Mr. Mfesane and Mr. Katz have kindly said that if we are given that opportunity, I should do it for all of us, just to save time. So that's the second thing. The third issue that I wish to address, my Lord, is just arising from a question from Justice Francis, and that's just a reference in the which answers the question which he asked, but it was not answered. And I'm not blaming Mr. Trenkov. Maybe he didn't see it in the report, but the answer is there. If I may, I won't be more than 10, 15 minutes.
No, 10 minutes.
10 is fine. Thank you.
I will give Mr.
Of course,
Trenkov
if I,
the opportunity
yes, especially if I stray into the merits, which I won't. Then he'll have his right of reply as well. Now, let me start quickly with the Dituku point. Dituku does not assist Mr. Trenkov with the greatest respect. If you go to the Dituku case at paragraph 34, yes. It says that it actually works against what Mr. Trenkov is saying. This is what it says there. And I accept Mr. Trenkov is not equating the NPA standard in this one. I accept all of the qualifications that he made. But this is what the case says. It is against this backdrop that I consider there was inadequate evidence before the NPA in charging the plaintiff to determine whether there was probable cause or malice on the part of the prosecutor. So this was a case about malicious prosecution. Then it says, the remarks of Jones J. in Mabona, that's another case, are relevant. Quote, the reasonable man will therefore analyze and assess the quality of the information. This the Justice Davis's issue about qualitative assessment. The quality of the information at his disposal critically, and he will not accept it lightly or without checking it where it can be checked, which will come to my next point. It is only after an examination of this kind that he will allow himself to entertain a suspicion which will justify an arrest in that case. This is not to say, this is the important part, this is not to say that the information at his disposal must be of sufficiently high quality and cogency to engender in him a conviction that the suspect is in fact guilty, which is the point we made yesterday, we all made. The sanction requires suspicion, but not certainty. However, the suspicion must be based on solid grounds, otherwise it will be flightly or arbitrary, and not a reasonable suspicion. So I'll just leave it there. So the two must be read together with that section, that 34. The next point is just to Justice Francis's question. That question is answered. My learned friend, as I say, Mr. Trenkov did not answer the question. That question is answered at paragraph 60 to 64, or even to 66 of the report. Justice Francis asked Mr. Trenkov, but shouldn't bad faith be inferred from the totality of the circumstances? That, with respect, is exactly what the panel said. Go to paragraph 63, it says, firstly, let's start at 61. It says what bad faith is and so on. I don't want to go. And then it reads the case of Public Protector versus Reserve Bank, the famous CX case, where Justice Mogoeng considered the meaning of bad faith. And then it cites paragraph 71 of that case to say it also means gross illegality, among other things. I don't want to read the whole thing. And then at 62, it says, this is the important part. This is so because the mischief sought to be rooted out by rendering bad faith so severely punishable, particularly within the public sector space, is to curb abuse of office, which invariably has prejudicial consequences for others. Abuse of office undermines the efficacy of the state machinery and denies justice and fairness to all the people and institutions. And then 63 is the direct answer to Justice Francis's point. They say, we think, this is now the panel speaking, we think that bad faith can be inferred from the nature and the circumstances surrounding the violation of the Constitution or the law and misconduct. So that's a total answer. And with the greatest respect, my learned friend, Mr. Trengo, accepts that bad faith would come from if it was intentional or willful and so on. But that's exactly what the panel said in 263. It said, viewed as a whole, that's in page 184, there was a deliberate intention not investigate the commission of the crimes committed at Palapala openly. Deliberate intention, they say. And at 264, which is the final, the order, if you like, of the thing, they say, now listen please carefully on this to show that they actually weighed the information and everything. This is what it says. This is the punchline of the whole report. In light of all the information placed before the panel, all the information, so they weighed everything and all that, we conclude that this information discloses prima facie that the president may have committed a serious violation of section 96(2), serious violation of PRECA, serious misconduct, acting in a way inconsistent with his office, and 4, serious misconduct, 96(2). Now, there's a question, I think it came from Justice Davis, and like Mr. Katz, and he says it's been troubling me. Justice Davis, we can't say that, as Mr. Trengov says, and I'm sure he didn't mean this literally. He says that the entire thing we're here about, and the rules, are here to protect the president against this kind of arbitrary committee or whatever. No. What about, I said this yesterday, the intention of these rules and the section 89 is also to protect the people against delinquent public protector, president, judge, or whatever it is. We can't forget that, because and that talks to something that Justice LaFrance raised yesterday. It's all very well to say, what if the review is successful? It's a legitimate question. And my learned friend, Mr. Trenkov, will say, what if it's successful? Of course, that's his side. We will say, what if it's unsuccessful? That's fine, we are adversaries. But the task of the judges of the court is different. In the balance of convenience test, it is to take both what Mr. Trenkov says and says, what if it's successful, but what if it's unsuccessful? And then say, which of those two harms? The harm to the people, if it is unsuccessful and all the time of the people would have been wasted in vain, or the time of the president, if it's successful and he's quote-unquote vindicated. That's the unenviable task of the judges, not us. We can do whatever we want here. But the judges must look at it both ways, both from the side of the president and the side of the people. And this court has said twice that in that exercise, the people must triumph for obvious reasons. Lastly, I'm sorry, I have to do this. Again, Justice Davis, please excuse me. I'm also revisiting something you and I were debating. You said yesterday correctly that you can't just look at the order dryly, and we agreed, I think, that you have to look at the judgment holistically. And I referred you to 139 and 141. Now, this is probably the most important submission we're ever going to make in this. The important thing, and this ties up with what Mr. Mukari said, about that the judges in the Constitutional Court were aware. This is about really the jurisdiction point. The judges in the Constitutional Court were aware of all these niceties about sufficient evidence and what have you. And despite all of that all of us who watched it on TV, we were not in that case, know that ad nauseum the whole day there was a debate about sufficient evidence, prima facie evidence, and I think Justice Rogers engaged more than anyone else on that. But how do you know that? You don't have to take it from me. Go to paragraph 32 of the Phala judgment.
It's 132.
32, my lord.
Yeah.
Look at E. It says, the president, supported by the ANC, opposes the application on the basis that, let's jump everything and go to E. He said, the panel had no evidence before it and misunderstood its mandate, which was to determine whether the sufficient evidence existed to warrant an impeachment process, and not whether information before it established prima facie that the president has a case to answer, as it found, and the report is fundamentally flawed by reason of various misdirections. So all of this, what Mr. Tengo was saying, was argued before the Constitutional Court. The Constitutional Court heard everything you've heard, and so will Part B Court. It's the fourth time now they're raising this. They raised it in the review that was abandoned. They raised it before the Constitutional Court. They're raising it now. They're going to raise it in September, and God knows how many more times they're going to raise it in the future. But with the greatest respect, and my learned friend has agreed that you only need a peak, that's fine. But that's not the point I'm making. The point I'm making is that, as Mr. Mukari said, the Constitutional Court, despite all this verbal gymnastics about sufficient evidence and what have you, said, oh, we hear all that, but we are referring this to the impeachment committee, and also do not pass begin. You must do it until that it is set aside. Those, sorry, yes, I don't think there's oh, I'm so sorry, I promise this is the last one. If you go also to 136 of Phala. Our submission is that the order you are being asked to do would offend exactly against that paragraph. Because this is what the Concord said. And again, this goes to this question as to whether you'll be varying the Concord's decision. It says, a rule allowing the National Assembly to thwart an impeachment motion at an early stage, which is what you're being asked to do, despite a finding that the complaint is sufficiently substantiated, would fall foul of the Constitution for multiple purposes. And let me pause here, Justices.
But isn't the Constitutional Court here talking about the rule of the National Assembly?
Yes, but I'm just saying the impact would be the same
okay.
of this. I accept that. But I'm saying the impact of what you are being asked to do would exactly be this. And this goes to what I said yesterday, Justice Elekrans, which is this. We cannot downplay the fact that what the Constitutional Court was saying is that, of course, all of us are entitled to go to court. Of course, all of us are entitled to interdicts and all that. But the Constitutional Court said, once the Rubicon of prima facie, sufficient evidence, whatever you call it, has been crossed, not with your lawyer. You must now wait in the cells, as it were. So once the Rubicon has been passed of sufficient evidence, then the process must proceed until and unless it is set aside. So that's what the court is saying here. And if you did otherwise, you would be changing the constitutional code. And then it says it would, for example, if you stopped it midway, A, foreclose any participation by any person or party in a further impeachment process. B, bar appropriate action, deny genuine platform for ventilation of informed views, deprive the citizenry the opportunity to be active, which really means the following. The president tells us about irreparable harm because somebody is going to defame him. How can this court interdict something so speculative? Who is this person? Who are these people who are going to defame him? And they're going to say what? We don't know. He doesn't tell us. He doesn't tell the court. But on some speculative basis that somebody might say something defamatory, this court must intervene. And the intervention of this court must be on the basis that there might be some irreparable harm which is undefined, which might happen. Because it cuts both ways. Mr. Trenkov correctly says, and Justice Lehanse put that to me, but the president says he has put his version out there. But so has Mr. Fraser. So has all the people who are supposed to defame him. So what is it? So the damage is done. What is it that we must interdict? Scott, please.
Thank you, Mr. Mpofu. Mr. Greenberg.
Please, the court. My learned friend, Mr. Katz, addressed you because he said I had failed to address something which he thought I would. Well, if I failed to address something, why, that would give him an opportunity to add to what he's already submitted. But he's dead wrong. The very first topic I addressed was the scope of the order sought. And let me do it again, because it seems as if my learned friend, Mr. Katz, didn't hear it, that others might have missed it. But I made it very, very clear. I started off by referring to the notice of motion, the very self-same paragraph that my learned friend complains about. I went to that paragraph and pointed out, that paragraph 1.2 of the notice of motion, and pointed out that it sought to interdict the commencement of the impeachment inquiry. And I then went on to submit and point out that even in the founding affidavit, it was made clear that the complaint is directed at the public evidence maligning the president. That was made clear in the founding affidavit in paragraphs 12, 13, and 103, as I mentioned yesterday. Apparently, my learned friend missed. And then the president came back and replied to clarify at paragraph 32 that he seeks only to interdict the hearings of the impeachment committee. And now my learned friend asserts that the president may not seek relief in terms other than his notice of motion. Well, that isn't so. It is open to a party to reduce the relief sought. The president that firstly sought a wider interdict that would stop any inquiry process. He's now made it clear again and again that he now asks for lesser relief, i.e. the commencement of the evidence. So my learned friend was wrong. He was not entitled to a further address, and I addressed the issue at some length. My learned friend, Mr. Mpofu, argues that the panel did consider whether there was prima facie evidence that the president had acted in bad faith. But he relies on paragraph 63 of the report. Paragraph 63 is a discussion of the theory of the requirement. It says nothing about this case. So it's clear that they understood the law on what bad faith means. And that is spelled out in paragraph 63. But there's no application of that test. There's no question ever asked whether there is sufficient evidence that the president had acted in bad faith. And in fact, in the concluding paragraph to which my learned friend relied, simply said that there is prima facie evidence that the president transgressed the paid work and the PRECA rules, with no suggestion that he did so in bad faith. So there's absolutely no evidence, and it's made clear, in fact, that the panel did not consider whether those transgressions had been committed, whether there was sufficient evidence, or even prima facie evidence, that the president had transgressed those rules in bad faith. My learned friend, Mr. Mpofu, tells us of the arguments that were made in the Constitutional Court in the Pala hearing. Now, I wasn't there, and I accept what he says.
Were you there?
No, I was not.
Oh, were you not there?
No. No wonder the president lost.
Well, Mr. Mpofu, he was also not there. So.
But let me say this. Whatever was argued before that court, what is absolutely plain is that it did not purport to determine any of these issues before you. It did not apply its mind to it, and it made no determination of any of these issues. So for my learned friend to say, well, it was argued and not decided, and that is indicative of anything, is, with respect, just not so. It might have been matters argued before the court, but the court chose not to decide those issues, and it gave its decision, understandably, on a different issue, and that is a more fundamental issue, and that is the process that must be followed when an incriminating report is brought out. Then my learned friend says, but the people must be protected against a corrupt president. But of course, the people must be protected against a corrupt president. But the people must also be protected against impeachment proceedings humiliating a president for which there is no justification. And the people's representatives in the National Assembly have defined what the criterion is that must be applied. So the people have an equal interest in the disciplining of delinquent presidents, but also in the protection of presidents against unfounded accusations. And it created a process to serve the people. And the people is best served if that process is properly implemented. They're not served by taking shortcuts in breach of the rules which have been designed exactly to serve the people. So it's no easy slogan to say the people want blood and therefore there must be blood. That is not the law. Thank you.
Anything else you would like to clear up with you? Thank you, Mr. Trenklerf. On behalf of this court, we would like to thank counsel for the manner in which they addressed us. We will deliberate on this issue, and hopefully by the end of next week, we'll deliver judgment in this matter. Court will adjourn.